Hello guys, welcome to LawPutra YouTube channel, and our today's topic is right and liabilities of mortgage under Transfer of Property Act. Nowadays, mortgage is a very commonly used word. Every single person has the knowledge that if he wants a loan to be sanctioned, he has to pay some collateral for that, and he has to mortgage his property with the bank. Mortgager and mortgagee are the two parties who have an important role to play during a mortgage of property. Various statutes that are available in India deals with the mortgage, like the Transfer of Property Act 1882, the Civil Procedure Code 1908, the Indian Contracts Act 1872. So now the question which arises in the mind is, when do rights and liabilities of mortgager arises? The rights and the liabilities of mortgager arises during a mortgage. A loan may be secured or be unsecured. Where a loan is given simply on the basis of debtor's promise to pay, that is on promissory's note, such loans are called as unsecured loans. But where the creditors take security from the debtor or for the repayment of his money, the loan is known as secured loans. One such way to secure loan is mortgage. The Section 58A of Transfer of Property Act 1882 has defined mortgage as a transfer of an interest in a specific immovable property for securing. Rights and liabilities of mortgagors are covered under the Section 60, 60A, 60B, 61, 62, 63, 63A, 64, 65 and Section 66 of the Transfer of Property Act 1882. Starting with Section 60, that is right to redeem. Section 60 of the Transfer of Property Act 1882 clearly states the right of mortgagor to redeem. The right to redeem is the right to recover something by making certain kind of payments. It is actually that the mortgagor has the right to back or recover certain property after making the payment of the loan. It is the right which vests the mortgagor by virtue of his residuary ownership in his property. As stated above, mortgagor's right of redemption has been mentioned under Section 60 of the Transfer of Property Act, and hence it is a legal and statutory right in India. In some cases, clause on the redemption occurs where there are conditions and stipulations which prevent the mortgagor from redeeming the mortgage property on the payment of the loans, and in India the clause on redemption is void because no condition or stipulation can eventually prevail against the statutory rights guaranteed by the Section 60 of the Transfer of Property Act. For example, let's take the case of Gulab Chand Sharma versus Saraswati Devi, where the Supreme Court clearly held that the stipulations on the mortgage deed was a clause on the right of redemption, and hence it can be enforced and it stands to be void. So mortgagor can exercise the right of redemption in the following ways, that is, either by paying or tendering the mortgage money to the mortgagee, and by depositing the mortgage money in the court, or either by filing a suit for the redemption. Right of redemption can be extinguished by the rights of parties, as when the parties themselves stipulate it for the separate agreement. So it can also be done by the decree of the court, but such decree must be the final decree of the court. Moving to the next, that is Section 60A. Section 60A of Transfer of Property Act 1882 states the obligation to transfer to the third party instead of retransference to the mortgagor. This section enables a mortgagor to require to the mortgagee as in not to retransfer the mortgage property to the third person, but in fact transfer the mortgage itself. Moving to next section, that is Section 61 of Transfer of Property Act. It states that the right to redeem separately or simultaneously under this section, a mortgagor who has already executed two or more separate mortgages in favor of the same mortgagee eventually will get the right to redeem any one mortgage separately or any two or more mortgages together. This section also does not recognize the equality of consolidation. Moving to next section, that is Section 62. The right to recover the possession. The Section 62 of the Transfer of Property Act 1882 states the right of unfructuary mortgagor to recover the possession. Under this section, the mortgagor is entitled to recover the possession of the mortgage property and with the mortgage deed under the following circumstances. Firstly, upon the payment of the principal money or upon the expiry of the term prescribed for the payment of mortgage money. So, in the case of K. Variath versus PCK Haji, the Supreme Court clearly stated that when an unfructuary mortgager could not be recovered possession on the basis of an oral mortgage, as it could not be proved for the want of the registration, it was open to him to recover possession on the strength of his title. It was stated in the case of K. Variath versus PCK Haji. Moving to the next section, that is section 63. Section 63 of the Transfer of Property Act 1882 states the accession to the mortgaged property. So this section incorporates rules relating to the accessions or to the mortgaged property, and it has also provided that in the absence of any contract, the mortgager is entitled to the accession while redeeming the mortgage. Moving to the next section, that is section 63A of the Transfer of Property Act. It states that the improvements to the mortgage property, the section was included by the amending of section 1929. This section provides that if in the absence of any contract, if the mortgage property has underwent any improvements that held during the mortgage, the mortgager will get eventually liable to those improvements without paying any cost. Moving to the next section, that is section 64 of the Transfer of Property Act. It states that the renewal of the mortgage lease. It provides that if the mortgage property is the leasehold property, so during the continuance of the mortgage, the mortgagee will get the lease renewed, and then on the redemption, the mortgager will be entitled to have the benefits out from that new lease. Moving to next section, that is section 65 and 66. It provides for the liabilities of a mortgager under the Transfer of Property Act 1882 for the implied contracts. According section 65, the Transfer of Property Act 1882, it states that the implied contracts by the mortgager, this provides with the liabilities of mortgager which are implied in every mortgage. These liabilities are deemed to be in every mortgage except where the parties have agreed to do so. And now the last, that is section 66 of Transfer of Property Act. It states that the waste by the mortgager in the possession. This article imposes a liability on the mortgager as in not to do anything which is destructive, which is injurious, and can be proved to be fatal to the mortgaged property. In all, this section provides that the mortgagee should not actively do anything on the property which in his possession or deals in a such manner which ultimately reduces the market value of the mortgaged property. So as we have understood it, moving to duties and liabilities of a mortgager. Along with the rights given to a mortgager, the Transfer of Property Act also conferred some duties on him. And the duties are as follows, like firstly, the duty to avoid waste. Secondly, the duty to indemnify for the defective title. Thirdly, the duty to compensate mortgagee. Fourthly, the duty to direct rent of a lease to the mortgagee. Firstly, the duty to avoid waste, that is under section 66. This section imposes a duty on the mortgager to not to commit anything that leads to the waste of the property or any act which reduces the value of the mortgage property, as explained above before. So waste is divided into two categories. Firstly, the permissive waste. What is permissive waste? Permissive waste is when a mortgager is in possession of a mortgage property, he is not liable to the mortgagee for any minor waste. Second, that is active waste. So in active waste, when an act is done which causes major waste of the property or leads to the reduction in the value of the mortgage property, then the mortgager will be liable to the mortgagee. So next, that is the duty to indemnify for the defective title. It is the duty of the mortgager to compensate the mortgagee for a defective title in the mortgage property. A defective title here refers to a situation when a third party states claiming or interferes with the mortgage property. It is a liability for the mortgager to come. So in a situation that If the mortgage property is in possession of the mortgagee who is paying all the taxes and other public charges, then it is the duty of the mortgager to compensate mortgagee for the incurring of such expenses. And similarly, when there is no delivery of the possession, that is the mortgage property is still in the possession of the mortgager, then it is his duty to pay all the public charges and taxes levied on him. Then the next is and last is duty to direct rent of a lease to mortgagee. When the mortgage property is leased by the mortgager, then it is the duty of the mortgager to direct lease to pay the rent, etc. to the mortgagee. Hence, here we conclude our today's topic. So, a mortgage deed comes up with many rights, many liabilities for both parties, that is, the mortgager and the mortgagee. But these rights and liabilities were created and included in the Transfer of Property Act in 1882, and hence it is a very quite old and therefore it is outdated law, though there is need for some amendments, as we have seen that there were some amendments made in the Amendment Act of 1929, but there has been no recent amendments have been made to the chapter of rights and the liabilities of a mortgager. This had led to various fraudulent transactions as both as the mortgager and for the mortgagee as well, and they have found various new methods of deceiving each other. Therefore, the need of the hour is to amend the laws and make it more stringent so that no party attempts to enter into a fraudulent transactions. Thank you.